Committee on Civil Rights, Judiciary, and Public Safety is called to order. Will the clerk please call and announce the roll?
Chair Chang.
Here.
Senator Shink. Here. Senator Voino. Here. Senator Irwin. Here. Senator Santana. Here. Senator Runstead. Here. Senator Johnson. Here. Madam Chair, you have 7 members present. There is a quorum.
I'll entertain a motion to adopt the committee minutes from the March 12th, 2026 meeting. Motion made by Senator Shink. Without objection, the minutes are adopted. Last week, we heard testimony on Senate Bill 626 from Senator Hertel, and there is a substitute. There is an S1 that you should hopefully have in front of you, and the substitute simply strikes the
Senator Johnson. Madam Chair, on the motion to adopt the S1 version of Senate Bill 626, there are 7 yeas, 0 nays. The substitute is adopted.
I'll entertain a motion to report Senate Bill 626, the S1 sub, to the floor with recommendation that it pass. Motion made by Senator Voino. Will the clerk please call the question?
Chair Chang.
Yes.
Senator Shink. Yes. Senator Voino. Yes. Senator Irwin. Yes. Senator Santana. Yes. Senator Runstead. Senator Johnson. Madam Chair, on the motion to report Senate Bill 626 S1, there are 7 yeas, 0 nays. The bill is reported.
Thank you very much. Next, we are going to take testimony on Senate Bill 737 from Senator Voino. This is allowing the Department of Corrections and the Parole Board to have some greater discretion. And Senator Voino, we're looking forward to your testimony.
Thank you, Madam Chair. And again, thank you, Madam Chair, and members of the Civil Rights, Judiciary, and Public Safety Committee for the opportunity to give testimony today on Senate Bill 737. This bill amends Public Act 232 of 1953 of the State Corrections Code to clarify parole eligibility requirements for an individual who's sentenced to life in prison with the opportunity for parole. Under current law requires parolees be supervised for a period of not less than 4 years, and this legislation takes a more realistic approach to parole supervision by modifying the mandatory minimum 4-year supervision requirement. Let me emphasize that the bill does not remove the authority of the parole board to review each case and an individual's eligibility for parole. Research and evidence has proven that an individual who may be prone to relapsing or violating parole requirements is going to do so in the first year. The current 4-year mandatory parole requirement uses valuable and scarce resources that can be better allocated towards more immediate and pressing concerns with the Department of Corrections. This bill is supported by the Michigan Department of Corrections and various prison reform advocates and ensures consistency in parole eligibility standards. The legislation also reinforces that extended sentences remain under the standard parole rules while maintaining fairness and transparency. In addition, it aligns statutory language with best practices in the correctional system and provides clarity for the Department of Corrections and the Parole Board. I want to thank the chair and colleagues for the opportunity to speak in support of this legislation and for your consideration in adopting this legislation to promote uniformity and fairness in Michigan's parole system. Additionally, we have Kyle Kaminsky from the Michigan Department of Corrections here today that will answer any questions that committee members may have. Again, thank you for your consideration, and thank you, Madam Chair.
Thank you very much, Senator Voino, for your work on this bill, and we appreciate you bringing it forward. We do have a question from Senator Runstead.
Thank you. So this is for cases involving severe offenses resulting in life sentence, or is that incorrect? A life, or first-degree murder, first-degree criminal sexual conducts. Is this applicable to those cases from what I'm reading?
Okay. I'd like to ask Kyle Kaminsky from the Department of Corrections if he could come forward and address many of the questions that we may have this afternoon. Thank you.
Kyle, come on up. And if you want to share some remarks about the bill as well, that would be great.
Yes, for the record, Kyle Kaminsky with the Michigan Department of Corrections. Thank you, Madam Chairwoman, and to the sponsor for bringing this bill up. I do have some general remarks, but I think it makes sense maybe to just answer that direct question to start. The bill applies to those sentences that can result in a life with the possibility of parole, and that can be a wide variety of drug-related crimes. It could be murder in the second degree. It could be certain CSC crimes. It does not apply to non-parolable life sentences, which would be murder in the first degree, which is actually the much larger group of individuals who are serving life sentences in Michigan. Those cases are not impacted. They're not eligible for parole under any circumstances. This is just for the cases that currently under the law are eligible for parole, and does not impact, and kind of shifting into my talking points, does not impact the parole decision process. So this in no way increases the likelihood that one of those cases would receive parole. It does not grant eligibility for parole to anybody who does not already have it, nor does it accelerate eligibility for parole. Basically, all the bill does is it says once the parole board goes through its existing statutory requirements for reviewing these cases, if they're going to grant parole, they can then make a determination of how long that term of supervision will be. They do that currently for all other cases in the state of Michigan. So they're making that decision in somewhere between 6,000 and 6,500 cases a year. But because of the statutory provision that has existed for some time, for these cases, they're automatically required to issue a 48-month parole term. That 48-month parole term is not evidence-based, and it's not a good use of our resources. So as we're thinking about public safety and our resources, we would really like to be able to direct our supervision resources to the cases that present the highest risk to the community. But when we have to basically hold low-risk cases on supervision for an extended period of time, we're not really getting much out of that from a supervision perspective, but it is taking our supervision resources away from other cases. We had last year in 2025, 45 people parole under this provision. So we're talking again about just a very small segment of the total number of paroles. And what will happen basically if this bill is passed and signed into law is by removing that 48-month mandatory requirement, the parole term and requirements will default to legislative language that was adopted in 2020 with overwhelming bipartisan support. And I don't usually work off notes, but I did actually bring notes for this because I didn't want to misstate what the statute says. But basically, the pertinent part of the statute says the conditions of the parole must be individualized, must specifically address the assessed risks and needs of the parolee, must be designed to reduce recidivism, and must consider the needs of the victim, if applicable, including but not limited to the safety needs of the victim or requests by the victim for protective conditions. So by removing this sort of blunt 48-month must order language that's been in statute for a long time, this will now become the language that will apply to all these cases. So again, victim input, public safety, reducing recidivism, but giving the parole board that authority to determine the best length of supervision to accomplish those goals. And with that, I'm happy to take any additional questions.
Yeah, I've made another concern. I have a lot of relationships with police officers throughout southeastern Michigan. And I've asked them, what are some of the biggest problems you deal with? And they said, a huge problem is these guys on parole that are running cops off the streets, stealing cars primarily. Rap sheets a mile long, and they were saying that virtually none of the judges are reoffending for parole. So in the old days, the first thing that's happened, okay, you're on parole, we're reoffending parole, so you're going to be dealing with that as well as the new crime. They said not one of the judges they're dealing with, and all these guys are still working, said if I was retired, Senator, I'd be happy to come in and testify, but the retribution will come on me if I disclose this publicly. But yeah, it's a huge problem of them not re-offending the parole currently. And then I sat in with the parole officer, who's one of the top parole officers, and I was there for the whole afternoon listening case after case of people that were like psychotic murderers. And she said, all I could do is try to keep them as long as I can. They're going to get out. And she said, yeah, they're going to murder again. These people are psychotic murderers. So the idea that this is going to be helping society, yeah, it'll save some money. That's probably why the judges are doing it. It'll save some money. But that is not helping the public safety here of the people in the state of Michigan. Thank you.
Go ahead.
Respectfully, I have my doubts that anybody involved in the Michigan parole process would make a claim like that, because ultimately the parole
I
board.
was on the tape with her. I was talking to her. I was right off.
Senator, he was in the middle of responding, so
Okay.
I'll go ahead and
In a
finish
life-
your statement.
For a parolable life sentence, which is the sentences we're talking about here, many of these folks don't actually parole at any point in their life. That is basically their sentence. So there's no obligation to parole in these cases. We're just talking about cases in which the parole board finds, through a majority of the parole board, having gone through a public hearing process, gone through the whole process, that this person would not present a risk to the community if released. And again, the bill in no way changes that dynamic. All the bill says is once that decision has been made according to statute, the parole board can then order the appropriate parole supervision length. It could be 4 years, as it is required in statute today. But in many cases, if that person is doing well and they're not causing problems, it would be a misapplication of resources to keep them on supervision when those same supervision resources could be reapplied to other cases. So we're not in any way seeking to shift the public safety scale here. The processes for determining parole remain the same. These cases are not there's no obligation to grant parole in these cases, but there are cases within this group where parole is warranted. And historically, cases in this group have low recidivism. These tend to be much older individuals by the time they're released. And so in those cases, we're simply seeking for the parole board to have the authority to select a supervision term length, which can be extended. If the person is not doing well on parole, they can extend it, but select an initial parole supervision term length that's appropriate to their risk.
The police officers told me the recidivism rate is looking so good because the judges are not reoffending for parole violation.
We do have a question from Senator Johnson, but before that, could you just remind folks of, the thorough process that the parole board goes through to approve someone to go on parole, and then also how often, a parole officer interacts with the person on parole to see how they're doing?
Yep, so these cases are unique in that they go through the most rigorous parole review process. So a parolable life sentence in Michigan now in modern times means you must serve at least a minimum of 15 years before your first parole eligibility. So at the 15-year mark, the parole board will start to review these cases. They can move them forward, or they can simply say that there's no interest at that time. If there's no interest, the case will sit for another 5 years. Statutorily, it has to be reviewed every 5 years from that point on. And so every 5 years, these cases come up for an initial review by the parole board. If there is interest on the part of the parole board, in these cases specifically, these parolable life cases, they then have to notice a public hearing where the prisoner will participate in a public hearing along with the option for the prosecutor, any victims, the Attorney General's office, and any other member of the public, for or against parole in that case, to participate and basically have their comments entered into the record. The parole board will then take the information from the public hearing, they'll discuss amongst themselves, and then you need to have 6 of the 10 active parole board members approve parole, in which case the case will move forward with an actual parole. Notice will be given to the prosecutor and any victims at that point. There's a notice period during which the person is not physically released. They remain under our custody in case the prosecutor or the victim would like to appeal that positive parole decision. If they appeal, that goes to the circuit court, potentially the Court of Appeals, depending on how that case proceeds. But if there's not a successful appeal or no appeal, then the individual will be placed on parole in their community. They'd be assigned to a supervising field agent. Their frequency of reporting will be relatively high when they start, and then depending on their performance and their conduct, it can go down. It can also be impacted by other things like, are they employed or not employed? Those that are not employed have higher reporting frequencies than those that are employed. Do they have a drug history? If they do, they have to do mandatory testing. So they'll have a higher reporting frequency. And what is their risk? So higher risk individuals get sort of stratified and they'll have a higher reporting frequency as well. As they progress through their parole, their agent can make determinations about sort of their progress, where they're at in that process. For a normal non-lifer case, once they hit the 50% mark, if they're fully compliant, the agent can even potentially seek to have their parole term shortened or discharged with the parole board. But in this case, because of the statutory requirement, they would have to remain on for the full 48 months under the current law.
Thank you very much. And just to make sure committee folks are aware, right, that this is not, this is a very thorough, thought through process. And so we appreciate you running through that, because I think it is important for us to understand the amount of work and checks that are in place. So thank you. Senator Johnson.
Yes, I just have three real quick questions. Do you have the statistical information that the comment is that after the first year, for many people, the next few years are not really important? Do you have that statistical information?
We can certainly provide information about kind of the incidence of recidivism by year. I don't have it right on me in my notes. Again, also, this is a very unique subpopulation that served a long time, so they have much lower recidivism generally.
Sure. I would just be interested in that. And
Okay.
I think sometimes parole is to catch them doing good and thank them for that too, to continue that. In courts, when you have like a second-degree murder, isn't it often that it's first degree, but they'll plead down?
That could be the case. I mean, that's ultimately up to the prosecutor. The other thing to keep in mind, though, is that when you're doing plea discussions, you're not required to do a parolable life sentence. You can just do a term of years sentence. So if the prosecutor wanted them incarcerated for a certain period of time, that could just be entered into the plea negotiations. And for instance, they could agree to a minimum of 40 years rather than a parolable life sentence, which technically could result in parole after 15 years. But certainly, the final charge code or final charge, agreement could be a plea deal. That could be a plea down.
I think it often is, both for criminal sexual behavior as well as for murder. But thank you so much. I would be interested in seeing how that works out over the 4 years.
Yep, I will get that information.
Thank you so much.
Thank you very much. We appreciate it. Up next, we are going to hear from Priscilla Bordeo from Crime Survivors for Safety and Justice. And with her is Harvey Santana from Alliance for Safety and Justice.
Thank you for having me. Good afternoon. I'll be honest, my team helped me write up exactly what I wanted to say, but after just listening to that, I think I just want to change it up a little bit. I am a victim and a survivor of sexual assault. You're probably wondering why a victim would support this bill, especially someone who, because I'm someone that believes in restoration and I trust the poor board, actually makes a lot of sense when you look at it through public safety and healing lens instead of just punishment. It prioritizes smart public safety, not just longer punishment. As a victim, my priority is safety. And this bill doesn't reduce that. It keeps the parole board fully in control, allowing the experts to decide what level of supervision is actually needed based on risk, behavior, and readiness. Not everyone requires the same length of supervision to stay safe. Over-supervising low-risk individuals can actually take resources away from monitoring high-risk ones. It trusts the system that already protects victims. This bill does not change parole eligibility or release decisions. Victims still will have a voice, can have their input, and are part of the process. It simply adjusts what happens after someone is already deemed safe for release. Another point that I wrote was it aligns with restoration and rehabilitation, something I'm a big fan of. If you believe in healing and restoration, then you believe that people can change, accountability matters, growth should be recognized. This bill supports that by allowing supervision and match actual progress, not just a fixed rule. It also uses resources where they matter most. Long one-size-fits-all supervision can overload the system, spread resources too thin. This bill allows the system to focus more attention on individuals who pose higher risk situations that truly require closer monitoring, which ultimately makes communities safer. It also reflects both justice and compassion. Supporting this bill doesn't mean minimizing harm, it means holding both truths. What happened matters deeply, and healing and accountability and transformation matter too. There's a powerful place to stand as a survivor. And as a survivor, I support this bill because I believe in accountability and restoration, and real public safety means using wisdom, not just length of punishment. Thank you.
Thank you very much. Appreciate your powerful testimony. Harvey, anything you want to add? All right. Any questions from committee members? All right. Thank you very much. Madam Clerk, could you read in the testimony cards?
Certainly, Madam Chair. All of these cards are pertaining to Senate Bill 737. Not wishing to speak in support, Harvey Santana, representing the Alliance for Safety and Justice. Again, not wishing to speak in support, Kay Perry, representing MI Cure. Not wishing to speak in support of the bill, Scott Preston, representing the Michigan League for Public Policy. Not wishing to speak in support of the bill, Gabrielle Dressner, representing ACLU of Michigan. Not wishing to speak in support of the bill, Matt Saxton, not wishing to speak opposed to Senate Bill 737. Matt Saxton, representing the Michigan Sheriff's Association. And the last testimony card, not wishing to speak in support of Senate Bill 737, Chuck Warpowski, representing the Michigan Collaborative to End Mass Incarceration. That is all the cards, Madam Chair.
Thank you very much. Up next, we are going to hear testimony on Senate Joint Resolution F from Senator Moss. Senator Moss, please join us, and we're looking forward to your testimony.
Thank you, Madam Chair. I appreciate the willingness to put this on the agenda today, as we are here to discuss the future of the marriage ban language in our state constitution that has existed for 22 years, enforced for the first 11 years, and not enforced for the last 11 years, but nevertheless is still there. Back in 2004, Michigan voters approved language in our constitution that states, quote, "The union of one man and one woman in marriage shall be the only agreement recognized as a marriage or similar union for any purpose." That's not just a marriage ban, that is a civil union ban as well, which makes Michigan's language, along with Virginia, among the two strictest equality bans in the country. One of the most aggravating aspects to me of the ban is that not only was this the state blocking a civil right to get married at the county clerk's office, but also blocked marriages in religious institutions that recognized, sanctioned, and performed same-sex marriages during that period. The state was perpetuating civil rights discrimination and religious discrimination. Michigan's marriage ban was subject to a federal suit in 2012 brought by then attorney Dana Nessel, the attorney in DeBauer versus Snyder. That case, filed by April and Jane DeBauer Rouse, who you will hear from soon, was among the cases from 4 states brought before the U.S. Supreme Court in 2015 and included in the Obergefell decision that ruled that these and all bans across the country were unconstitutional. Marriage equality prevailed in Michigan due to Obergefell and only due to Obergefell. In 2022, President Biden signed the Respect for Marriage Act, requiring that the federal government and U.S. states to recognize the validity of all same-sex marriages. As of today, all same-sex marriages in Michigan are protected in federal law. But as we know, there is a renewed political movement to overturn Obergefell, including here in this legislature from Republicans in the Michigan House of Representatives calling on the Supreme Court to do just that. Justice Clarence Thomas himself wrote in his concurring opinion in Dobbs, which overturned Roe versus Wade, that the justices should reconsider Obergefell as well. And you'll hear more on that from both Jay Kaplan and Sam Bagenstos. If Obergefell is overturned, Michigan snaps back to the language in our state constitution banning same-sex unions. The Respect for Marriage Act requires Michigan to recognize existing marriages and those from other states, but no new same-sex marriage licenses would be issued in the state of Michigan. I was 18 years old in 2004. It's a very vulnerable time to come of age. And the marriage ban wasn't just an absence of rights. It was an active harm on the community. Those 11 years robbed me and people like me of possibilities for our futures. We cannot go back to that dark era. So what can we do? The only way to strike the marriage ban language from our Constitution is to repeal it by a majority vote from the public. There are two ways to bring a vote to the public to repeal the marriage ban language in our Constitution. One, sufficient petitions are collected to place it on the ballot. Or two, 2/3 of each legislative chamber votes to place it on the ballot, and we're here today with that option. Gallup has been tracking polling on marriage equality since at least 1996. In their most recent 2025 survey, 68% of respondents were in favor of same-sex marriage and only 29% against. This is not 2004 anymore. People respect the rights of their friends, family members, neighbors, and coworkers. This resolution would keep the status quo exactly as we have it right now. I am handing it off next to my friends Jane and April, who were really the perfect faces of marriage equality in Michigan, and they have an incredibly compelling story. Their effort was to form a state-recognized union of love between each other, legally protect that bond, and ensure their children had the full rights to health, safety, and well-being. Passing this resolution is about the most pro-family thing we could do in the legislature. So I can take any questions, but really want to uplift Jane and April to tell their story.
Thank you very much for your leadership on this. Looks like we do have a question from Senator Runstead.
Thank you. I've often felt that the dowry rights is antiquated and that things have changed since I think this was constitutionally passed in 1860-something. And it made no sense at all with current situations. I mean, this was written in a whole different world. However, you've conflated these two in your resolution, a different constitutional amendment with this dowry amendment, and why did you put those together in the resolution?
I think it's to ensure that the language reflects that there are same-sex spouses, not just husbands and wives.
Certainly, if it were the dowry one, which I've complained about for decades, I could support that. The other one, I have issues with. I don't want to get into all that, but it's just a shame that we can't clean up this dowry issue, which is completely makes no sense at all. Thank you.
All right, why don't we go next to Jane and April DeBoer, who are on Zoom. Welcome. And, oh, there we go.
There we go.
There we go.
Sorry.
Welcome.
Thank you for having us.
And you're welcome to begin your testimony.
So I'm going to start off by thanking Jeremy Moss for having us on here. Sorry, Senator Jeremy Moss. So we all know that Obergefell approved that same-sex marriage was legal, as we were part of that, representing Michigan. Our biggest concern, or my biggest concern, is that since having those rights granted, and we are currently protected and recognized as a family, every day we get threatened by someone or a group that those rights could be taken away. And living in that fear, no longer being recognized as, legal parents or a couple is concerning for us. The thought of becoming a legal stranger to my children again is devastating to me. We've raised these kids since they were infants, and they consider us their parents. We consider them our children. And I do mean ours, not mine and my wife's. We also fear being considered a second-class citizen again, which is what we were before Obergefell went into place. I'm going to turn it over to April for our story.
So Jane and I started our journey to the Supreme Court and being part of Oberger-Fell simply because we wanted to adopt each other's children. Um, Jane had adopted two boys from the foster care, one from the foster care system, one from a private adoption. And I adopted two girls, both from one from a private adoption and one from a foster care situation. And as many may or may not know, on a snowy day on a two-lane highway, we came very close to a head-on collision that probably would have killed Jane and I, or at the very least myself. Um, and with that realization, we went to Dana Nessel asking to put some legal paperwork into place. And Dana said, well, we can do that, but they don't have to follow what you put in. That we need to challenge the adoption ban in, or the two-parent adoption ban in Michigan. So we decided to challenge that because if something had happened to either one of us or both of us, our kids would have been separated because they were legal strangers to each other. The boys would have gone to probably family in Indiana, and the girls would have stayed up here with family in Michigan. And we couldn't fathom that that these children who had been raised together were going to be separated. So we first started with the second parent adoption ban, and as history is, Judge Friedman said, well, that's fantastic, but I don't think that that's your problem. I think your problem is you can't get married. And so we went on to challenge the marriage ban here in Michigan, and then later got involved with and put in with the Oberger-Fell um, case. And as again, history states, we did win. However, we are now living in a time that we feel that this could all be taken away from us. That we could be legal strangers to each other, we could be legal strangers to our kids, and that upcoming families are going to be treated like we were originally, where you're not going to be able to adopt children together, which is going to cause probably some issues with adoption and people not wanting to take kids because they don't have legal rights together. Again, the rights that marriage brings to us, it's a hardship. I mean, legal paperwork that has to be done, that any judge could just say, no, I don't believe that that's correct. If we don't have the marriage option. So, and the protection, correct. And the protection of marriage and protecting our children in that aspect as well. As Jane said, we don't want to go back to being second-class citizens. We don't want other people to feel like they're second-class citizens. Our marriage in the last 10 years has not affected anybody but us. It has done no harm to anybody. It hasn't changed anything. It's a legal contract between two consenting adults that state they want to be together and, in our case, raise a family together. I don't know how that harms anybody in the state of Michigan. Thank you.
Thank you both. We really appreciate both your leadership and your courage over the past many years, as well as bringing your voice today. Are there any questions or comments? Senator Shink.
I just want to say thank you for taking the steps that you needed to take to protect your family and to think about the future. and to be out there as a public face for what's really just basic equality and basic stability. And I could probably turn it into a question, but I just want you to know how much I appreciate all that you're doing. So thank you, and how much you love your kids.
Thank you.
Thank you.
All right, any other questions or comments? Okay, thank you. Up next, we are going to hear from Jay Kaplan from the ACLU of Michigan. If you could, sorry, there's a button at the bottom of the mic, and then that way we'll be able to hear you just a little bit better. And those
There
watching.
we go.
Thank you.
Okay. Good afternoon. As staff attorney for the ACLU of Michigan's LGBTQ+ project, I appreciate the opportunity to speak in support of repealing Michigan's 2004 constitutional amendment that prohibits same-sex couples from marrying and from having the legal benefits and protections associated with marriage. I've been an attorney for more than 40 years, and I've worked in the area of LGBTQ rights for the past 35 years. During this time, I've seen firsthand the collateral damage that has been done to LGBTQ couples and their families because they could not legally marry. Partners being denied the ability to visit each other in the hospital, to have a say in medical decisions when one partner is incapacitated, partners not being able to be with their loved ones at the time of death due to disenfranchisement by family members. This was especially true at the height of the HIV/AIDS epidemic in the 1980s and 1990s, which disproportionately impacted the gay community. Partners being evicted from the home they shared with their deceased loved one due to family members inheriting the deceased property without a will. Children being denied the legal protection and economic stability afforded by two parents. Children losing contact with and continued care by their co-parent because that parent-child relationship was not recognized by law and only could be recognized by marriage. Partners unable to cover their partners under their health insurance because their relationship was not recognized by law. Same-sex partners unprotected financially under law if their relationship ended through dissolution or death. Michigan's marriage amendment was passed by voters in 2004 and was packaged as a policy initiative that preserved the status quo at that time, that only opposite-sex couples could marry. But that was a lie. And Michigan's then Supreme Court majority held that what voters approved was far more extensive. It took everything off the table for LGBT couples. No right to marry, no civil unions, no domestic partner benefits, and no recognition or acknowledgement whatsoever by any state or local government of a same-sex relationship. And that also included health insurance coverage. In fact, the Michigan Supreme Court decision resulted in Michigan's marriage amendment being one of the most extreme in the country. It was only when in 2015 that the U.S. Supreme Court held in Obergefell versus Hodges that to deny same-sex couples the right to marry is unconstitutional, and that Michigan same-sex couples finally had the legal protections for their same-sex relationship and the stability for their families. In the past several years, we've seen unrelenting attacks against the LGBTQ+ community, with more than 800 anti-LGBTQ bills introduced just last year in state legislatures, a majority of them attacking transgender people in every aspect of their lives, including accessing health care, accurate identity documents, and using bathrooms. This doesn't include the 9 to 10 executive orders issued by the Trump administration seeking to erase the existence of transgender people and to deny them the same dignity and fairness afforded to other people. This continues to be the most immediate danger and harm to the LGBTQ community, and this cannot be ignored or discounted by policymakers. But make no mistake, these attacks are part of a trajectory. To attack transgender people first and then move on to gay and lesbian people, to strip them of the right to marry and those benefits and protections of marriage. We already saw the Michigan House Republican majority introduce a resolution calling on the United States Supreme Court to overturn the marriage equality decision. Similar resolutions have already been introduced in 8 other states. The United States Supreme Court earlier this year refused to take up Kentucky Clerk Kim Davis's case, calling on the court to reverse itself. But we do know that two current serving justices, Thomas and Alito, have criticized the marriage equality decision and have called on the court to revisit. We can safely assume that in the next several years, a case challenging marriage equality will make it to the United States Supreme Court, and Michigan needs to be prepared for this possibility. But perhaps even more important to this issue is the fact that Michigan's Constitution exists to protect everyone, to guarantee that every Michigan resident has the same opportunities and dignity. Michigan's marriage amendment is a stain on that promise. It singles out LGBTQ people for discriminatory treatment in contravention of what our state civil rights laws say and what equal protection under the law is all about. And just like what Colorado, California, Hawaii, and Nevada have already done, Michigan's amendment should be rescinded. Thank you for your time.
Thank you very much. I really appreciate what you said about the current attacks on really vulnerable members of the community being part of a trajectory, I think were the words you used, and I think that's really important context for us to consider. Are there any questions from committee members? All right, thank you very much. Up next, we're going to hear from Sam Bagenstos, who is a law professor at the University of Michigan, and he is joining us on Zoom.
All right, thank you very much, Madam Chair. I really appreciate the opportunity to come here to testify in support of this resolution, which would remove the ban on same-sex marriage from our state's constitution and instead enshrine marriage equality in that basic charter of Michigan's government. A little bit about me. Since 2009, I have held an appointment as a tenured professor of law at the University of Michigan, where I write and teach and study in the areas of constitutional law and civil rights. I've also been centrally involved in civil rights litigation in state and federal courts, both as a private attorney and at the U.S. Department of Justice, where I was an attorney and then Principal Deputy Assistant Attorney General for Civil Rights. I'm here today in my personal capacity, although my testimony draws on my extensive experience as a constitutional lawyer and a scholar. As you have heard, in November of 2004, the voters of this state added Article 1, Section 25 to the Michigan Constitution, an incredibly broad ban on marriage equality as well as on civil unions and anything like that. But Article 1, Section 25 has been unenforceable for more than a decade. Since its 2015 decision in Obergefell, the United States Supreme Court has held that it's a violation of the 14th Amendment to the U.S. Constitution for a state to ban gay and lesbian couples from marrying. The Obergefell ruling has been widely popular. Opinion polls consistently show that approximately 2/3 of Americans agree that gay and lesbian couples are entitled to marriage equality with straight couples, and recent Michigan polling paints a similar picture. Article 1, Section 25 is an outdated, unpopular, unconstitutional, and at the moment unenforceable provision. So why is it necessary to remove that provision? After all, Obergefell stands as a shield to protect Michiganders from being subject to its discriminatory prohibitions, correct? Well, yes, for now. But with a very aggressive United States Supreme Court, we cannot at all guarantee that Obergefell will remain on the books. To the contrary, when the court overruled Roe v. Wade in its 2022 Dobbs case, Justice Thomas wrote a concurring opinion in which he explicitly said that, quote, in future cases, we should reconsider all of this court's substantive due process jurisprudence, including Griswold, Lawrence, and Obergefell, end quote. So Justice Thomas put Obergefell on the chopping block, and an increasingly determined movement is working to make good on his promise. As one conservative publication put it just last month, quote, what looked like a settled cultural consensus in the mid-2010s is now fracturing as the right increasingly treats marriage equality not as a closed question, but as a live front in the broader fight over social norms. And conservative lawmakers around the nation have introduced legislation that would tee up a challenge to Obergefell. We have seen late last year the noted conservative lawyer Jonathan Mitchell filing a case in Texas in which he's trying to get the U.S. Supreme Court to reconsider Obergefell, and most notably in January of this year, a group of conservative organizations, notably including the Heritage Foundation, which brought us Project 2025, initiated a project specifically seeking to overturn Obergefell. It doesn't matter that these efforts are taking place largely outside of Michigan. If they succeed and the Supreme Court overturns Obergefell, our state's constitution and its provision discriminating against gay and lesbian couples will spring back into place. Article 1, Section 25 has never been removed from the Michigan Constitution. It's just been unenforceable because of Obergefell. If Obergefell goes, Article 1, Section 25 returns automatically. And it will return even though the polls show that Michiganders would not vote for that provision today. That's why it's especially important that the legislature adopt this joint resolution. That measure would remove Article 1, Section 25 and its discrimination against gay and lesbian couples from our state's constitution. It would also amend Article 10, Section 1 to remove any sex distinctions in marriage and thus make clear that gay, lesbian, and straight couples would all have the same right to marry. Those who oppose marriage equality would have a full opportunity to try to persuade the people to vote against that amendment if the legislature were to send it on to the people. But if the people vote for marriage equality, as all of the polling indicates they would, gay and lesbian couples will be protected even if the U.S. Supreme Court overturns Obergefell. The lesson of Roe and Dobbs is clear. Even very popular decisions of the Supreme Court are not safe in the face of an aggressive campaign to overturn them. This legislature should trust what Justice Thomas and conservative activists are telling us they want to do, which is they want to overturn Obergefell. This legislature should not trust the self-assured reassurances of those who say, no, 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 Obergefell is safe. Senate Resolution F is necessary to protect marriage equality in Michigan, and I'm pleased to testify in support of it and very happy to take any questions that this committee has.
Thank you very much for your expertise and for your testimony. Are there any questions? Okay, thank you very much. Up next, we're going to hear from Emily Barr, who is an attorney joining us today.
Hello, thank you, Madam Chair. I'm a little short for this chair. As you mentioned, I am an election law attorney. I'm also appearing on my own behalf as a lesbian who is married to a woman, so understandably interested in this subject. But I actually want to give you some election law context for this resolution versus a citizen-initiated ballot proposal. So you heard Senator Moss mention that there are two avenues to amend the Constitution. One is what we're doing right now, which conforms to what other states have done and are doing, which I'll get to in a minute. But the other option is a citizen-initiated ballot proposal. That has a lot more requirements to it. And so if you're talking about like a grassroots movement of people who are really dedicated to this, you've heard Senator Moss and others mention there's broad support for this change. Even so, those people would have to come together, form a ballot question committee, abide by a lot of election law that they may not have the savviness to understand, and then they would have to collect at least 500,000 signatures. The reality is 500,000 is the amount that's required by the Constitution. But when you look at people signing a petition might sign the wrong form because they didn't realize they live in Oakland County now or whatever, you have to have more than that. So you're talking about really like 750,000 signatures that if you have a grassroots organization trying to do that, it's a lot of time, it's a lot of volunteer coordination. Even when you have like a dedicated organization that has done something like that before, it's a lot of time, it's a lot of coordination and making sure you have all of that to get something on the ballot that Michigan voters want to vote yes on. The other option is this legislative option. And it's not to say that this doesn't also require work. I mean, we're all here today, but it is not the same onus on Michigan residents as the citizen-initiated ballot proposal would be. And I mentioned this is in keeping with what other states have done. So I think Mr. Kaplan mentioned Colorado, Hawaii, Nevada, and California have all removed these provisions from their constitutions. As sort of a brief history lesson, these constitutional prohibitions on same-sex marriage all went into effect from the late 1990s to, I think the latest was the late 2000s. So like, I think there was a ballot proposal in Minnesota in 2012 that got rejected to add a similar provision to their constitution. At the time, there was a lobbying push to add these. This wasn't, as other people have mentioned, this wasn't something that everybody necessarily wanted. It was something that was advocated for. Even if it was something that people wanted then, it certainly isn't now. It is an outdated amendment to our Constitution that doesn't need to be there, that Michiganders don't want there. Nevada took the first step and in 2020 removed a similar provision from their constitution. That started as a legislative proposal that was later voted on by voters by over 60%, with over 60% approving. California, Colorado, and Hawaii all did the same in November of 2024. And again, all had overwhelming support to remove those provisions. Other states, Virginia and Delaware, are currently in the process of taking a legislative step to get this in front of voters. Virginia's governor just signed a bill that will put this in front of voters in November of this year. So it's not as if Michigan taking this step, would be, I guess, stepping out in front of where progress really is. This is in keeping with the times. This is in removing an outdated, unnecessary provision from Michigan's constitution, and it conforms to federal law, removing it. So I think it's important to reflect on the fact that a citizen-initiated ballot proposal can run out of steam even when everybody in the state wants to see this done. And this route, taking the legislative route, still gives voters the choice. It's not like you're taking a voice away from voters in the state of Michigan. This still gives them the choice, but it just doesn't put this unnecessary burden on them to go through all of this process when the legislature can do it.
Thank you very much. We appreciate you sharing that. Are there any questions or comments? Okay, thank you very much.
Thank you.
And we are now going to hear from Corinne Rockoff from the Ruth Ellis Center.
Good afternoon, Madam Chair. My name is Corinne Rockoff. I'm the board chair for the Ruth Ellis Center located in Highland Park, which is a nonprofit organization that was established with the goal of creating more opportunities for LGBTQ plus young people where they can thrive and pursue their goals. One of the populations that the Ruth Ellis Center serves is LGBTQ plus young folks who are in foster care. So I'd like to begin by addressing the proposed joint resolution with them in mind. Protecting same-sex couples' rights to marry in the state of Michigan supports LGBTQ plus young people in foster care because those children are more likely to have safe, supportive experiences with same-sex parents, and protecting their marriages will help create more supportive homes for LGBTQ plus youth and for all youth who are in the foster system. LGBTQ plus youth are overrepresented in foster care, particularly transgender youth, and around 1 in 5 children in foster care identify as LGBTQ plus. They are generally more likely to have negative experiences than the overall population of children in foster care, and they are more likely to be living in group homes and to have been unhoused at some point in their lives, as compared to the population generally. These children in the foster care system, like all children, need and deserve safe and loving homes, and same-sex parents adopt and foster at much higher rates than the general population. 24% of same-sex couples who choose to become parents adopt versus only 3% of different sex couples. 4% of same-sex couples who choose to become parents foster, as compared to only 0.4% of different sex couples. More than 35,000 same-sex couple parents had adopted children, and 6,000 were fostering children as of 2024 data from the Williams Institute. And the majority of those couples are married, just like Jane and April DeBoer. Protecting same-sex marriage in Michigan means creating more opportunities for youth in foster care, and specifically for LGBTQ plus youth to grow and thrive and grow up in supportive homes in our state. Beyond that positive impact, the change will have specifically for those in the foster system. This amendment would also express support for the futures of all young people in Michigan. Updating the state constitution and giving the voters an opportunity to speak on this subject will send a message to LGBTQ plus young people in the state today who are growing up in Michigan that their state government has their back and genuinely is committed to ensuring that all young people in this state will have the opportunities to grow and thrive and build the lives of their choosing here in Michigan, including when it comes to their rights to marry and build their own families. Finally, stepping outside of my role for a moment as board chair for the Ruth Ellis Center, I'd like to personally express my support for this resolution in my own capacity. I moved to Michigan in 2018, and I have been married to my wife since 2020. We had a backyard COVID wedding. And the text of Article 10, Section 1, as it currently stands, just fails to align with the reality of my life and my family and my marriage. I'm a Michigan transplant, but since day one, I have felt genuinely welcomed by the Midwestern kindness of the friends I've made in this state, of my neighbors, who are your constituents. My wife and I have chosen to build our lives and our family here, and now with our 3-year-old son, we intend to be Michiganders for the rest of our lives. So I know, even though I haven't spent that many years here, I know that Michiganders are kind people who have a genuine respect for their neighbors. That is the reality of what people in this state believe. The polling shows it, and that's been my experience as someone who lives here. And most people have absolutely no idea that this befuddlingly outdated and exclusionary language is still lurking in our Constitution. My family has been incredibly lucky not to have had to live in fear the way that the DeBoer family did. And this change would help ensure that no family in the future has to experience what they did. We are very grateful for the work that has come before us and do not want to lose that. I want my son to grow up knowing that his family will remain safe no matter what happens at the federal level. And so on my own behalf, I believe that making this change would simply bring the text of our Constitution up to speed with reality. We're already here, we're already married, we exist, and it's the only thing that makes sense in modern Michigan to make sure that our Constitution for the state reflects that and reflects where we are already. So thank you very much for your time.
Thank you very much, and we're so glad that you're here in Michigan, and we're grateful that you're going to stay. But thank you very much, especially for highlighting the impact on young people, a really important aspect to talk about. Senator Schenk.
Thank you. I think people should be able to marry whoever they want, regardless of whatever else, right? So, but my question is, more I want to say, but I'm trying not to say it all, because I'm not testifying. But one of the things that you mentioned is that you came to Michigan, and you are employed, you are contributing to our state. You and your wife have created a stable home, which is important. And I'm wondering, if we were to if we didn't have those assurances for you and your family, it seems like that would affect the economy of Michigan. Do you think that not doing this affects the economy of Michigan? If people are worried about whether this is a safe place to be, that it affects our businesses because the best employees are going to choose to go to a state where they are safe and where there is a stable political environment?
Absolutely, without a doubt. I mean, I grew up in Southern California. I've lived in Pennsylvania and in DC before this, and I chose to move here. My wife and I decided that this is where we wanted to be because we wanted to be near family and we wanted to be in the Midwest. I like being near fresh water. It's lovely. But because within those parameters, Michigan was a safe place that we knew we could be, where we knew that there was genuine support for our existence and our ability to build a family and a community. And in the absence of those protections and that confidence, it would have been very hard to make that decision and feel safe coming here. And since moving here, I've had friends and family joke that there should be some kind of stipend from, I don't know, some entity within the government. Yeah, because, I mean, my parents moved here. My dad lives in Franklin now, and we've brought other people out here. I feel like I genuinely advocate for the life that we've built here because I do love it, and I'm happy to be here. And I want to continue to live in a Michigan that takes care of my family and the others in our community that I think would be so happy to build a life here as long as they're continuing to feel safe doing so and bringing all the wonderful things that they have to bring to our communities.
Thank you. Senator Irwin.
Yeah, I just want to take just a moment to thank you for being so overly generous in your description of the people of Michigan, because we do have this reputation of being the kind of place where folks are going to walk down the street and they're going to say howdy, they're going to say hi, how are the kids, you know, your lawn looks great, whatever it is, right? But what lies behind that is a willingness to vote for and maintain laws that fundamentally discriminate against other people because of who they love or what they look like or what their accent sounds like. That's not pleasant. That's not kind. That's not the kind of state I want to live in. And so thank you for being here to help us actually live up to that description that you so generously placed on the people of Michigan. And I think we have a ways to go.
I think perhaps things were, I've only known the Michigan that I've lived in, and perhaps the mood was different at the time that this was initially added to the state constitution, but the modern Michigan that I know, that I live in, those are the people that I know and who I consider to be my community. And I think that people today, regardless of what they thought when this was passed, people today are a lot closer to who I think they are. And that's what the polls tell us as well, is that when this is put to the public for an opportunity to express how they feel, I have faith in my friends and my neighbors and your constituents that they will be the people I know them to be that I've met since I moved here. So I hope I'm right.
And I think that we have been changing, but you know, the backstabbers, they'll smile in your face, as the OJ said, right? And so actions speak louder than words. And I'm just sick of people who are pleasant out front, but then behind the scenes they're willing to deny the basic rights of other humans. And I'm reacting to it, so thank you for the opportunity and the forbearance, Chair.
Well, thank you very much, and also thank you for the work at the Ruth Salles Center, which is an incredible organization. I think that today's hearing is hopefully another important step forward towards progress and towards the Michigan where we want to make sure that every single person has the opportunity to thrive. Okay, Madam Clerk, could you read in the cards?
Certainly, Madam Chair. In regards to Senate Joint Resolution F, in support of the bill not wishing to speak, Rachel Richards, representing the Michigan League for Public Policy. Also in support of Senate Joint Resolution F, Mary Pollock, representing the Michigan Unitarian Universalist Social Justice Network. And that is all the cards, Madam Chair.
All right. Being no further business, the Senate Committee on Civil Rights, Judiciary, and Public Safety is now adjourned.